Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Hey everyone, welcome into an all-new episode of Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson. Over at Battleson Law LLC, I am your host, Mike Leon. Today's episode, we're going to be diving into commercial lease negotiation strategies, tips to protect your business, avoid costly pitfalls, and secure terms that work in your favor, whether it's your first lease or your fifth. Mark shares all the insider strategies every Georgia business owner should know. Mark, it's good to see you as always. Atlanta's building a lot now, so they're going to need your help, a lot of folks out there. So let's talk about this, negotiating leases. What should every Georgia business owner know before they enter into a commercial lease negotiation?
Well, thanks for having me, Mike. I think the biggest thing is just understanding the magnitude of what it is that you're getting into. You're taking on a serious, large liability. And when you do that, as well as all the startup costs are going to come with that business. And so I've run into a lot of folks that believe that they can just, they've got a letter of intent at the outset, as I've said in previous podcasts, and they think that they understand the actual terms of the lease. And a lot of these commercial leases, I mean, they're 30, 40, 50 pages long of small print. And those words are there for a reason. They're there drafted by the landlord to protect the landlord's interests and ensure rent collection and the ability to evict if the tenant goes into a monetary default, which is non-payment of rent, or just a non-monetary default for some other breaking of or breach of the lease.
So, Mark, I imagine a lot of business owners, they dread negotiating any type of lease. What's the first step that they should take before even opening the lease?
Well, actually, I mean, getting into a lease is a long process. I mean, site selection is critical, obviously, for the success of a business, especially retail. But even office, industrial, I mean, et cetera, they're all going to need to make sure any prospective tenant should. A lot of times I see tenants, they find a spot and they just get it in their head that is where they want to be. The landlord typically will have a landlord's rep broker, but a tenant rep broker, especially when you're searching for retail or office, I think, can be really helpful to a prospective tenant. And there's usually a split commission paid by the landlord where a tenant rep broker can assist you in taking a look at multiple sites. And then they aren't going to be beholden to any one landlord, albeit maybe the commission structure is a little bit better for one or the other. So you do need to watch out for that. But long story short is, it isn't just the lease. I mean, it is site selection and then getting into negotiating the terms of that lease and understanding what the comparable rents are and making sure that you're getting a good economic deal, which can include a lot of different terms. Tenant improvement allowance, which is landlord paying you to build out the space for your use. And that is important, and it's a means of financing the lease. Now, your rent may be higher, but getting cash in early while you're more of a startup type shop and not coming out of pocket for some of the tenant improvements can really help a tenant out. So I think, I haven't even gotten to the question of the lease itself, but getting yourself properly adjusted and have a letter of intent that actually is where I or a lawyer helps negotiate the terms beyond what maybe a tenant rep broker might do is probably money well spent to just have an hour of time on the letter of intent before it ever gets submitted to the landlord. So that is maybe your one bite at the apple to negotiate base rent, additional rent, tenant improvement allowance, maybe a cap on the guarantee, et cetera. There's a lot that goes into that. And again, I'll use this phrase a lot. Retrading after you have negotiated something in an LOI, it's considered to be bad form, and landlords get ticked off because then once they produce a lease, they've spent a couple $1,000s of lawyer time to generate the lease, even to customize it to your situation.
Well, let's drill a little bit more into the lease, like you were saying. So what clauses, and we talked about this in a previous episode, but what clauses in a commercial lease sometimes have the biggest long-term impact if they're overlooked by the business owner?
notice and cure provisions. So there's going to be a default section in a lease, and that default section is basically non-payment of rent, as I just mentioned in the last question. But also just, if you're operating your business in hours that is not permissible, if you're a restaurant and you don't have the proper exhaust systems, and then food smells are going into a neighboring property or neighboring unit, which maybe is a clothing store. There's going to be a lot of different things that you can cause you to default on a lease. And you want to make sure that for monetary, which is payment of rent, or non-monetary defaults, that you get a notice and cure provision in there. Most landlords will give that. Some are super difficult about it, but most of them understand that, hey, look, mistakes happen. You got to be able to notify somebody and allow them to take corrective action before you then go for the remedies of a default, which could be eviction. And an eviction and that remedy is a brutal process. It destroys businesses, and you want to make sure you're avoiding basically the death knell type consequences associated with a lease. Usually you can work things out if you have a professional landlord and if you're professional, but if it becomes at a loggerheads, you want to make sure that your lease gives you some level of ability to fix the problem.
And how do you identify, Mark, like which lease clauses are most flexible for negotiation for your client and which are usually just non-negotiable non-starters?
I mean, I've been doing this a long time, so it's really just based on experience. And then each landlord is different. Some landlords are fairly easy to work with. Most of them aren't. Most of them hire very good lawyers that also understand what is negotiable and what is not. And again, each landlord's going to have their own little areas where they just don't negotiate. And so, basically, there's a marketplace out there, though. So you need to be competitive as a landlord, both on the rents, the terms for additional rent for under triple net, and making sure that your landlords do need to be competitive, unless they just have this a unique property that everybody wants to be in. It's usually not the case. So it really just comes from experience, and then I wouldn't call it trial and error. It's just more of there are some idiosyncratic or unique positions that certain landlords take, and sometimes there's a lender of the landlord or a private equity group backing that landlord that has certain requirements as well. But everything is always a negotiation, and until you sign, you can walk away. And having the ability to walk away, both at the letter of intent stage when you're really negotiating the business terms and prior to signing the lease, that is the one bit of leverage you get. Once you sign that lease, you are very pregnant and you don't have a lot of choices after that.
Yeah. So, Mark, in keeping with that theme, how are you also helping clients manage or at least weigh the short-term lease flexibility against long-term financial obligations?
Well, there's not a lot of short-term quote lease flexibility. I mean, you're negotiating something that's going to be pretty much set in stone. Now, on the front end, before you sign it, that's important to make sure that you have negotiated everything that you're intending to get out of this transaction and have the ability to walk away. Now, the one thing I would say as far as the broader global situation is I have had clients who have signed a franchise document and they are paid for a franchise agreement, and then they start looking for space, and then they start looking for an SBA loan or something like that in order to finance the entire business. It's dangerous to do that because I've seen people sign leases in advance of certain things, or sign loan documents in advance of certain things, or sign a franchise agreement. Trying to get all those done at the same time is far better, because you don't want to sign on a loan or a lease without making sure that you've got your other components of that business model or the business plan in place. Because if you need $400,000 to build out a space and have working capital for a startup, you better make sure you have your loan teed up before you sign a lease that's going to obligate you for the next 5 to 10 years to pay rent. And maybe you've even designated that lease is supposed to be under a franchise concept or a certain brand or a certain use of the permitted use for the business. And then you have to change the business model, and then you got to get the landlord's permission to do that. So trying to keep everything on kind of a critical path toward one closing or a series of closings right in succession will help de-risk everything for you, because you don't want to take steps that commit you to something without every other thing that needs to be done in process or soon to be completed and committed.
Mark, let me ask you, staying on that, what mistakes in your years of experience have you seen clients make when they try to negotiate these leases without seeking someone like your expertise and the legal guidance?
It just takes a lot of time, education, and experience. And most people don't have the patience to read through a 50-page document of small print, of mind-numbing, a lot of definitions. So it's like, you need to understand how to say, okay, well, this definition, how does that definition then cross-reference into the actual legalese that is going to be the controlling language? And so that's what a lawyer does. Lawyers are expensive, I get it, but what a lawyer does is takes a look at, hey, what's your total liability? And again, if it's $100,000, $200,000, $500,000, spending a few $1,000s negotiating commercial lease does two things. It hopefully gets you a better deal and maybe saves you tens of thousands of dollars on the economics at the letter of intent phase and even during the lease negotiation phase. But the default and de-risking of the lease itself and making sure that all of the gotchas that are in there are resolved as clearly as possible and maybe even summarized for the tenant or client. But on top of that, tenants really got to ask themselves, am I really going to go through this thing with a fine-tooth comb with the amount of experience and understanding what can and can't be negotiated and do it properly? So it just takes a weight off of the tenant. For one thing, maybe they don't have the skills to do it, but even if they did, I can do plumbing, but I don't do it because I'd rather have a professional come in there and knock it out in 2 hours rather than me spending all day doing it and ruining my weekend. And yeah, I got to pay for it, but takes it off my plate. And it's something I actually know how to do, but because I worked construction when I was a kid, but I just don't want to do that. So, and I know it's going to get done more right than if I did it myself.
Yep. Very well said. So for the business owner out there, Mark, that's listening to this episode, and maybe they are about to negotiate their first lease, what's one key piece of advice you would always give to them to protect their business and especially their bottom line?
Yeah, it's super practical. It is, think about what your business is, what it needs, what timing is going to be necessary in order to get things done for both, be it financing, if you have a franchise relationship, business partners, and everything else. And you really need to map out the timing of this on just a linear basis and make sure that you're then meeting all the deadlines that are going to be necessary. There are some soft deadlines where just missing an opportunity, but if you're going to end up having a commercial lease negotiated, making sure that you're just making progress and making sure that the letter of intent is so important. I cannot emphasize it enough. I get letters of intent dumped on me all the time, and they've missed great opportunities for free rent, deferred rent, a tenant improvement allowance, which is cash to help you do the construction. And again, that may lead to higher rents, but it's also about cash flow. Cash flow is the lifeblood of a business. You need to make sure you got enough money to pay for everything until you start making enough money off that business to be cash flow positive. And a great business can run out of cash and die, even though it really didn't do anything wrong except mismanage its accounts payable, accounts receivable, and construction costs and things like that. So long answer to the lease is super important. Don't get me wrong, but starting on a path where you understand the timing and when you understand the process and where and when you can negotiate certain things is where I come in.
Yeah. Mark, thank you so much for the time, the insights, breaking this all down. I truly appreciate it.
Thank you so much.
And that wraps up today's episode of Atlanta Business and Commercial Real Estate Law Podcast. If do me a favor, big thank you to Mark Battleson. You want to connect with Mark Battleson, him and the team, do me a favor, visit battlesonlaw.com today. If you're facing a commercial lease negotiation, you just want to make sure your next agreement doesn't come back to bite you, go visit Mark and the team over there. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.